the topic of disclosure within care proceedings. And the authorities aren't particularly new, but it's an issue which comes up time and time again. I thought it useful to have it all in one place. Shout out to Kim, who's helped me immensely with the research. Now, we start off with disclosure to third parties, and in particular the police. The court has power under Rule 12 of the FPR to grant permission for information relating to court proceedings to be disclosed to the police, but all information in relation to care proceedings, whether or not contained in filed documents, can be provided to the police when acting in furtherance of the protection of children. And under PD 12G, the police and CPS are automatically entitled to transcripts of judgments from care proceedings. There are, however, limits to what the police can do with the disclosure, and I'm referring in particular to the information which the police get as part for child protection purposes. It cannot be disclosed, cannot be used for investigation or prosecution without the express permission of the family court, and the authority for this proposition is the case of Gillan. Now, the local authority can disclose to the police documents which are lodged at court or using proceedings which already existed prior to the commencement of proceedings. So these are all your PLO documents. And I've set out there what you can particularly do to find out what the local authority has provided. You will, of course, be familiar with Section 98 of the Children Act, which provides that a person will not be excused from giving evidence on the ground that it may incriminate him or a spouse. And the trade-off to that is Section 98(2), which provides that statements or admissions made in care proceedings are not admissible in evidence against that person, save for offences of perjury. And it is for the Crown Court judge to decide whether or not and to what extent Section 98(2) applies in any particular situation. Now, what then about disclosure to the police, disclosure made to the police otherwise than for the protection of children? And when this application is made, the court will consider the factors set out in Re C, which is affirmed in its entirety by the Court of Appeal in the Re-F case. I've set out here the Re C factors in the following two slides. I will recast them, but crucially, what the court said is that it's impossible to place any factor in the order of importance. The importance of each factor will inevitably vary very much from case to case. But the court did highlight that the welfare and interests of the children or child concerned in the care proceedings is important, welfare and interests of other children generally, maintenance of confidentiality, importance of encouraging frankness, public interest in the administration of justice, public interest in the prosecution of serious crime, punishment of offenders, gravity of the alleged offence, desirability of cooperation between various agencies, and the terms of Section 98(2) itself, and also what other material disclosures already taken place. McFarlane stressed that disclosure should only be granted if the criteria in Re C is satisfied and it is necessary and proportionate. Now, once the permission has been given to the police, what can they do about it? And in particular, can they use it in criminal trials? There I've referenced Section 12 of the Administration of Justice Act 1960 and Children Act 1989. And essentially what those two provisions do is prohibit the use, the publication of such information. So essentially it cannot be used in an open court, which criminal proceedings are, unless the family court has given permission. Now, the procedure, but not the test, for what happens when the police have got all of the information and they want to use it in a criminal trial is set out at paragraph 12 of the 2013 Protocol and Good Practice Model. At this second stage of the procedure process, I say second stage because the first stage is given to the police, and the second stage is to decide whether or not it can be used in a criminal trial. It would appear that the race EC test is once again applicable. And the restrictions can be dispensed by the family court if it is satisfied that the welfare of the child requires it. The circumstances when the restrictions may be dispensed with were broadened in the case of Norfolk County Council against Webster, and the court there decided that the welfare of the child should be read as a non-exhaustive expression of terms on which discretion can be exercised. In the case of Re-X, and what Mummy said was that it was important that there would be a balancing exercise of the interests of the children involved. And although it was important, it was not paramount. And you see that if all else fails, we can fall back on pace, but that's essentially something for our criminal colleagues to consider. Moving on to the next topic, which is immunity from disclosure. And this is essentially where there's an application made to withhold information or documentation from a party to the proceedings. The court's power to control or limit disclosure can be found in Rules 4, 12, 21, and 29. And it was confirmed in the case of Re-R, the 2021 case, that the family court has the power to control the use of documents. The default position, obviously, is that there should be full and frank disclosure of all relevant material unless a party raises issues of litigation privilege, legal professional privilege, or public interest immunity, in which case the extent of the duty of disclosure will be determined by the court. In the case of R&P, the Court of Appeal held that the analysis in O'Brien against Chief Constable of South Wales, a criminal case, applying family proceedings. And the stages of analysis identified in O'Brien was that obviously the evidence must be relevant. The judge will evaluate the potential significance of the evidence, assuming it is true, in the context of the case as a whole, and then go on to consider whether there were any reasons against admitting such evidence. And it's tried to say that the general principle is that the court should not base the conclusion adverse to a party to the proceedings, and particularly a parent, where that party has not seen the information and has had no opportunity of challenging it or contesting it. And case of Re-D, non-disclosure should be the exception, not the rule. Only order when the case for doing so is compelling. Jurisdiction only to be exercised in exceptional circumstances and for the shortest period possible. However, following the implementation of the Human Rights Act, the approach of it was decided that one cannot consider only the welfare of children in determining whether or not there should be immunity from disclosure, because the ECHR provides that Article 8 rights of adult parties, witnesses, and victims should also be taken into account. And this was confirmed in the cases of Rien, 1989, and B. And in particular, in the latter case, Among said that, in my judgment, Re-D can no longer stand as an authority for the proposition that only children's interests can be taken into account. Looking at the case of Re-C, the court considered the procedure to be followed where there was an application for non-disclosure. And unfortunately, Justice Johnson declined to lay down any rigid rules. He took the view that the procedure in each case will be determined by the court in light of the particular circumstances and demands of the case. In general, however, he said that the application should be transferred to the higher courts. Notice should be given, and the party to whom information was not to be revealed should have the opportunity of making representations. He also said that there should be disclosure in the first instance to counsel only, and thereafter counsel would have the opportunity to apply for onward transmission to the client. I hold that thought in your mind. That's called a closed material procedure. This particular case, Re C, was endorsed by the Court of Appeal in the case of Re M, save for the fact that the Court of Appeal said that not every case had to be transferred to the High Court. Looking at the case of HI, the 2017 case, the court adopted a procedure that has elements of partial withholding and a form of closed material procedures. That's the one I referred to you, where only the advocates were permitted to see the material. The judgment in HL crucially does not refer to the cases of Somerville and others against Scottish ministers or Brining and the Information Commissioner and others. And both those cases make it clear that any procedure that involves release of material to parties' advocates only to the exclusion of their clients should not be followed. And there's a general aversion to permitting counsel to see or hear evidence which he's not at liberty to disclose to his client. I'm not even sure that as advocates we are permitted to give undertaking to the court not to disclose information relevant to the case to our clients. Well, what then about the possibility of the clients giving us those instructions? Well, you can look at it, well, you don't have to let me have it. Well, leaving aside the possibility that the client can withdraw such instructions at a later point, we then have the case of A against Chief Constable of Dorset, where it was said that the court has no power to compel the claimant to instruct his legal advisors, permitting them to see material which is not supplied to him. Now, if the closed material procedure is to be avoided, what can be done? In 2015, the President issued guidance, the role of the Attorney General in appointing advocates to the court, or special advocates to in family cases. And the special advocate here would act as an amicus advising the court on the application. The issue of funding was considered in the case of armed material procedure. And Mr. Justice on the court pointed out that there was no clear guidance on who should fund the special advocates. We're very much, unfortunately, in the territory of making it up as we go along. So we're told now that it resolved. As indicated earlier, in the case of BC, it is to be determined on a case-by-case basis. And these are the potential ways, the appointment of a special advocate. But bear in mind that the use of special advocates is rare, and looking at the cases, they appear to be largely limited to cases where there's an element of public interest immunity. So we see it not infrequently in the immigration type cases where there's an allegation of terrorist activities, etc., and that sort of thing. We could potentially have a situation where, for example, the advocate for the local authority or the guardian considers the material in question and makes representations to the court. And a case that Christine's going to touch on earlier, that's exactly what happened. However, this really only works if either the local authority or the guardian is neutral on the application. So, for example, if you have the mother making an application not to disclose material to the father on the grounds that he has been very, very violent and abusive and you will track her down, etc. Unfortunately, it doesn't always happen. Quite often, the local authority or guardian will have very strong views on the matter. A third possibility is perhaps it goes to a different judge. That's happened in a case being suggested in the case of mine. So a different judge, not the trial judge, considers the material, and that way the trial judge is not tarnished by the material. Now, for this to work, the judge considering the application will need to have a knowledge of the case. The judge will need to know what material is being withheld, the relevance or otherwise of this, and the reasons for the proposed withholding. And the advocates would have to agree, as it suggests, a narrative to be put to the judge as to the parameters of the application, why, what is it, and the purpose, etc. But if you were the person who it is proposed, suggested the material should be not disclosed to, how will you be in a position to actually make proper representations to contribute to the narrative if you don't actually know what it is that's been withheld? And I had a case recently, for example, where the actual basis for withholding the information was crucial. It was a case where a child had made allegations against the father, and the child had made it very clear to the social worker, etc., like that she didn't want the father to know she even made the allegations, never mind what the allegations were, in circumstances where it's alleged that the father was extremely manipulative, etc. And the local authority did not want to disclose the basis for their application. Unfortunately, I don't have any clever answers, but it looks as if that these are the sort of things that we can decide, we can make representations to court on a case-by-case basis, and you will simply have to be inventive about it. Thank you.
Okay. Well, evening everyone. I am finishing off the public law update, and I am just going to go through a handful of cases that have come up out in the last 12 months that I think are quite helpful for practitioners practicing in public law. And the first one is another one in the long line of cases dealing with therapeutic disabilities. Re-D, perhaps the one which started the thinking in relation to it, and Re-H, in the most recent authority, tries to grapple with the very difficult issue of the balance to be struck between offering support and parenting the support, and the point at which it tips over into substitute parenting. That's unsustainable in the long term. At paragraph 67 of Re-H, the Court of Appeal set out a sort of helpful, logical way of thinking it through. And it talks about the interest of the child. The starting point is first to identify and describe the level of support needed by the family, then go on and ascertain what can and should be done under the local authority's obligation, and then finally determine whether with that in place, the child's welfare needs to be met. And it might seem obvious, but it's actually quite a straightforward process of thinking it through. In Re-H, they also highlighted the important consideration that it shouldn't be confused as to whether or not a child has a possibility of suffering, risk of suffering harm. There has to be an actual risk of suffering harm. Now, moving on to placement orders, and we call it placement orders, but really this is the case that I think most people may have touched upon in the last 2 months, and is an aim from a child lead to post adoption. Really, the reason that this case is highlighted is it talks about the importance of transcripts in all care and pleasing order applications. And Lord Justice Jackson sets out very helpfully why it is so important. And really, all local authorities now need to be mindful of it, and all public law practitioners. It's of huge importance to any child, to the birth family and to the adoptive family to really understand the reasoning behind any orders being made, and that will feed through to life story work throughout their lives. But the other reason, of course, is that there will be investigation, and we know the lines of authorities that have taken place since EBS and so on. The opportunity to object to an adoption order, an application to revoke a placement order, it is so important to have the benchmark. And as Lady Justin McCullough noted in Re-S, a transcript provides the baseline against which to assess what changes have occurred. Finally, at paragraph 7, what is set out is when the agreement may be placed into order, the court should always order the local authority to obtain the transcript of this judgment unless it's handed down a written version or has made arrangements to that be agreed in a brief note. And the same applies in case of final cause is named or that is deferred to the appeal. So it's important for all applicants to be alert to the need for a judgment in really all final challenges. The next case is the case that's been known as the Manchester case. This is another one in the line of many cases where Mr. Justice MacDonald appears to be the champion of case law in terms of deprivation of liberty. This particular case is notable because it changed the viewpoint of the High Court when approaching deprivation of liberty orders. For as long as I have known, in orders of deprivation of liberties, local authorities apply for and received orders preventing children from using their phones and other social media devices. And what the Court of Appeal, Listeners Justice MacDonald pointed out, is that in fact, in reality, that isn't subject to deprivation of liberty. It's not a deprivation of liberty, it's a restriction of liberty. And the reality is the local authority, if they already have a care order, are already in a position of exercising parental responsibility, overriding parental responsibility. And as such, as many parents up and down the country do, they are entitled to strict the use of mobile phones and social media. And so it comes into a whole different category, unless there is a particular refusal by a young person to hand it over. And that might be a situation where the High Court discretion might be invoked. Mr. Justice MacDonald is involved in the next case, which is NHS Trust and ST, which are accused of deprivation of liberty order. And this simply highlights the importance of local authorities if they are going to bring these very serious and draconian applications, that they need to do so in a timely manner. But in this particular case, the Court of Appeal were clear, and it simply left it too long, and they refused that application. Yes, a child and W child, Section 20 accommodation is a timely reminder of the use of Section 20 within care proceedings. Within that case, Lady Justice King gave me judgment, and she reflected on the fact that Rien, which I think is a case that I probably addressed to on a few years ago, had led to a reduction in the use of Section 20, because that had looked at the abuse of Section 20, where local authority had held us in Section 20, in reality, the situations where they should be issuing proceedings. But Rios takes us right back. He reminds us that Section 20 isn't limited in time, it isn't a short-term measure, and that ultimately, and in both of these cases, the Court of Appeal determined that where parents there was no suggestion they were going to withdraw Section 20, and there was no reason whatsoever, or looked at no order principle as to why that Section 20 shouldn't continue. It's the least influential principle. And within the Court of Appeal also very helpfully reminded us of what Section 20 in fact provides and when it can be used. And most of it's obvious for those of us who practice in this area of law, but it perhaps does serve in mind from time to time, because by agreeing with Section 20, the parents are delegating parental responsibility for day-to-day decisions to local authority. And it's perhaps also worth reminding that if there's a child arrangements order, namely a person with whom a child is to live, and that person leaves the child being accommodated Section 20. No other person with parental responsibility if you lose that child. The next case, VP, each adults, children mobile phone extension. I moved it because it caught my eye, but Dawn rightly reminded me, in fact, that's the case that she was involved in. That's where she is now. And that's the one that she touched on a moment ago. It was an interesting case because increasingly within the public arena and in private law as well, we are looking at applications for mobile phone disclosure. And in this particular case, there was a young parent, and they led the local authority seeking mobile phone disclosure, and the Guardian was very concerned about the ambit of that because they wanted full disclosure, not only of the messaging but also of social media, and they were concerned about the right to privacy of all the young people on the other end of it, as it were. You were not part of the proceedings, and whether or not it was fair and proper for that swing disclosure to take place. And the Court of Appeal said yes, in fact. There is limited guidance in relation to the and insofar as there is limited guidance within the family proceedings rules or the CPR, then the judge can, and in this case should draw upon perhaps in the criminal court to reform the conduct of the family court proceedings. And you'll see set out there that the police, of course, again, have to take a proportionate approach, and they have to be mindful of other people's right to private life, but ultimately the decision has to be met in relation to it is necessary, and it sets out within the H&L, and it's set out within the slides, the thought process and the thinking that has to be applied. What of course Phil did agree was the fact that being disclosure needs to be time limited, and again exactly to proportionality, I believe it in fact necessary and proportionate to the having full disclosure, or in fact that could be a much more focused exercise. Then finally, the case which I think so many practitioners at Republic Law or Reader have perhaps agreed with, they've come across it. It's a question of care orders at home. And this is the case where the Court of Appeal noted that this hadn't really been considered for quite some time. It's not groundbreaking, but it does serve to remind us again about the proportionality issue. And what the Court of Appeal noted, and certainly my experience was absolutely right, is that different local authorities are applying very different criteria in terms of whether or not to conclude proceedings under applying care orders. Surrey, for example, haven't done it for a very long time. Perhaps understandably, they don't want to share parental responsibility for a child who's at home. There's a limit to how much they can exercise that parental responsibility. Hampshire, over the border, have regularly been finishing their care proceedings by use of a final care order. And what the Court of Appeal reminds us and took us right back to is, again, proportionality, the interference. And what they reminded us, and it's set out there in the last slide, that we were in the extreme that the risks of significant harm to child are judged to be sufficient to merit the name of a care order, but nevertheless the risk being managed with a care order being made in favour of the local authority, with the child really in the care of the care and skilled carers. And that, I think, is probably the present all along, because they say, if we're that worried, we don't have a care order at home, it was to care. If we're not that worried, then we use the supervision order.